You know what? You know, no.
Then we'll bring this fool in. Good morning, sir. What's your name?
Brace yourself for a lineup of history's most clueless defendants, criminals who thought they could game the system and crashed spectacularly instead. From self-sabotage on the witness stand to accidental confessions, ridiculous excuses, and heated showdowns with judges. These unbelievable moments come straight from real courtrooms. We're diving into authentic cases, viral meltdowns, sentencing reactions, and some of the most jaw-dropping legal blunders ever caught on record. Number 8. Nathaniel Saxton's username becomes Exhibit A. Virtual courtrooms were supposed to make the justice system more efficient. What no one quite anticipated was that they'd also expose defendants' online habits in real time, sometimes to their own embarrassment. Few moments capture that better than the case of Nathaniel Saxton, a man who nearly talked himself into a contempt charge with a username. Saxton's court appearance took place during the COVID-era surge in remote hearings, when judges across the United States were relying on Zoom to keep cases moving. On this particular day, Saxton logged in for a routine hearing before Judge Jeff Middleton. Everything seemed normal until the judge glanced at the screen. "Good morning, sir. What's your name?" Judge Middleton asked. "Me?" Saxton replied, clearly unsure whether he was being addressed. "Yes, you," the judge said, prompting Saxton to respond with his real name, Nathaniel Saxton. That should have been the end of it. Instead, it was just the beginning. Judge Middleton then addressed the elephant on the screen, Saxton's Zoom display name. The username was explicit and wildly inappropriate for a courtroom, something closer to a crude internet alias than a legal identity. The judge made it clear that whatever was displayed on the screen was not acceptable in a judicial proceeding, especially one on the official court record. Saxton looked genuinely stunned. As he glanced at his own display name, his face told the story before his words did. He insisted he hadn't typed it himself, that his sister had done that as it was an inside joke, and seemed almost offended by the idea that he would intentionally log into court with such a name. "What kind of idiot logs into court like that?" he blurted out, apparently forgetting that, at that exact moment, he had. Judge Middleton was unimpressed. Calm but firm, he pointed out the obvious. Regardless of how it got there, the name was attached to Saxton's account, and responsibility rested with him. Virtual court, the judge reminded him, is still a court. The same rules apply, the same expectations apply, and yes, the same consequences apply. Rather than immediately citing Saxton for contempt, Judge Middleton opted for a measured response. He paused the proceedings and placed Saxton into the Zoom waiting room, delivering a line that would soon circulate widely online. Saxton, he said, could sit in limbo for a while and think about what you call yourself online. It was a warning wrapped in dry humor, but the message was clear. Courtrooms don't care about your gamer tag, your social media alias, or whatever name you use with friends online. When you enter a legal proceeding, even from your living room, professionalism is not optional. Saxton eventually rejoined the hearing with a corrected display name and a noticeably humbler attitude. He narrowly sidestepped a serious contempt charge, though the escape wasn't free. Judge Middleton told him he should be embarrassed while issuing a $200 fine, payable within 30 days, after a syringe in Saxton's possession tested positive for meth. When asked if his sister was present, Saxton replied, "No, unfortunately she is not." The judge didn't miss a beat. She should know she nearly landed him in jail for contempt. The moment quickly went viral, a sharp reminder of how casual internet behavior can crash headfirst into the very real consequences of the justice system. What if a crime was committed and the defendant doesn't just forget courtroom etiquette, but strolls in wearing the alleged evidence of his crime? Number 7. Nelson Walker's exhibits show up. Well, Nelson Walker created one of the most unintentionally hilarious court moments on record. In September 2011, Walker and a friend walked into the Miami Dolphins team store at Sun Life Stadium, home of the NFL's Miami Dolphins at the time. According to police reports, the two men browsed casually before allegedly stuffing Dolphins jerseys into their pants and attempting to leave without paying. Store security noticed the awkward bulges, alerted authorities, and both men were arrested on the spot. The charge, third-degree theft under Florida law, a felony offense given Walker's criminal history. So far, it sounded like a routine retail theft case, until Walker showed up in court. When his name was called during arraignment, Walker stepped forward wearing a teal Miami Dolphins jersey. Yes, the same kind of jersey he had allegedly stolen from the stadium store days earlier. The moment didn't go unnoticed. Judge Diane Ward looked up, paused, and clarified the charge aloud, noting, almost incredulously, that Walker was accused of stealing a Dolphins jersey. That's when Walker decided to help his own case. Sort of. He quickly assured the court that the jersey on his back was not the one he stole. "This ain't the one," he said, emphasizing that point more than once. Then, perhaps realizing how that sounded, he pivoted, insisting he hadn't stolen any jersey at all. His defense was less of a strategy and more of a verbal scramble, but it was memorable. Walker's public defender attempted a more traditional legal angle, pointing out inconsistencies in the police report. The arresting officer had written conflicting details about whether Walker and his co-defendant were seen wearing Dolphins hats or jerseys during the alleged theft. Hats, jerseys. Details matter in court, at least on paper. The defense hoped that ambiguity might cast doubt on the observation. Unfortunately for Walker, the jersey on your back argument wasn't the biggest issue working against him. Court records showed he had 29 prior felony convictions. That history weighed heavily in the judge's decision, and Walker was held on a $5,000 bond. As an added consequence, he was permanently banned from Sun Life Stadium, later renamed Hard Rock Stadium in 2016. Effectively ending any future Dolphins shopping trips. Then came the twist no one expected. Despite the viral courtroom moment and Walker's extensive record, Miami-Dade prosecutors ultimately declined to move forward with the case. The theft charge was dropped, and Walker was neither convicted nor sentenced in connection with the alleged jersey theft. Still, the damage, or fame, was already done. The image of a defendant arriving in court wearing what looked like Exhibit A spread quickly, earning Nelson Walker a permanent spot in the unofficial Hall of Courtroom Self-sabotage. But what if the man accused of one of the most brutal crimes imaginable decides he knows the law better than everyone else in the room and represents himself? Number 6. Ronnie O'Neal's self-destructive trial. In the case of Ronnie O'Neal, the decision to represent himself didn't just fail, it actively sealed his fate. Ronnie O'Neal's crimes were so disturbing that even seasoned professionals struggled to process them. Presiding Judge Michelle Cisco would later describe the case in blunt terms, calling it the worst she had ever seen, based on the facts alone. And this was a judge with years of experience on Florida's criminal bench. It all began late on the night of March 18, 2018. At exactly 11:43 p.m. Eastern Time, the Hillsborough County Sheriff's Office received a frantic 911 call from a woman later identified as Kenyatta Barron. She was hysterical, repeatedly telling the operator she had been shot and begging for help. When the dispatcher asked for her address, Barron struggled to respond, her voice fading in and out as the pain overwhelmed her. In the background of the call, a male voice could be heard shouting. Then Barron stopped responding altogether. What followed were screams so agonizing that the dispatcher repeatedly tried to re-establish contact, unaware that the woman on the line was dying. Minutes later, a second 911 call came in, this time from Ronnie O'Neal himself. O'Neal claimed he had been attacked by white demons inside the house and insisted that Barron had tried to kill him. He told the dispatcher he was the victim, not the aggressor. When deputies arrived, O'Neal was still ranting, shouting that Barron was the devil, and so were his children. Inside the home, officers discovered a scene that defied comprehension. 9-year-old Rona O'Neal had been hacked to death with a hatchet. 8-year-old Ronnie O'Neal Jr. was found alive but gravely injured, stabbed repeatedly to the point that his intestines were exposed. Kenyatta Barron lay dying from a gunshot wound. She would later succumb to her injuries. Ronnie Jr. was rushed to the hospital, where detectives interviewed him once he was stable enough to speak. From his hospital bed, the child identified his father as the attacker. He described hearing his parents arguing, seeing his father holding a shotgun, and watching his mother scream in terror. His memories faded only after paramedics placed a mask over his face. O'Neal, meanwhile, was taken into custody and questioned. At first, he invoked his constitutional right to remain silent, clearly stating that he wanted a lawyer and would not answer further questions. On its face, it was a smart legal move, but that restraint wouldn't last. When the case went to trial, O'Neal made a decision that stunned everyone involved. He waived his right to counsel and chose to represent himself. Despite the overwhelming evidence against him and the complexity of a capital murder trial, O'Neal insisted he could do a better job than any attorney. His opening statement made it immediately clear how disastrous that choice would be. O'Neal launched into an unhinged rant about government conspiracies, accusing law enforcement of fabricating evidence and describing the justice system as corrupt beyond repair. He claimed the prosecution itself was part of a larger scheme and promised the jury they would eventually see who the real mass murderer was. From the outset, the trial teetered on chaos. The prosecution, by contrast, methodically presented physical evidence, forensic findings, and eyewitness testimony. Most devastating of all, the testimony of O'Neal's surviving son. When it came time for cross-examination, O'Neal did what no defense attorney would ever recommend. He questioned his own child. He asked the boy whether he had seen him shoot his mother. The child answered honestly. He had seen his father holding the gun, but not the exact moment of the shooting. O'Neill pressed him anyway. Then he asked a question that froze the courtroom. "Did I hurt you that night?" The answer was simple and devastating. "Yes." "And how did I hurt you?" O'Neill continued. "You stabbed me," the boy replied. In any other trial, that exchange alone would have been unforgettable. In this one, it was just another nail in the coffin. As the proceedings continued, Judge Sisko repeatedly had to intervene, reminding O'Neill to follow courtroom decorum and keep his arguments grounded in evidence rather than personal attacks or profanity. She exercised extraordinary patience, even as O'Neill pushed the boundaries of what courts typically tolerate from a pro-se defendant. Then came closing arguments. O'Neill's final address to the jury was rambling, emotional, and increasingly incoherent. He accused witnesses of lying, prosecutors of misconduct, and the system of corruption. At several points, Judge Sisko had to stop him for using inappropriate language. And then, astonishingly, O'Neill confessed. "I did kill," he said, before trying to frame the statement as a misunderstanding and insisting the jury should tell it like it is. Whatever strategy he believed he was executing collapsed instantly. Any lingering doubt evaporated. The jury did not deliberate long. They returned guilty verdicts on all major counts, including first-degree murder. The evidence, combined with O'Neill's own words, left no room for ambiguity. At sentencing, O'Neill showed no remorse. He told the court he was not sorry for something he claimed he didn't do, and not sorry for the things he admitted he did do. Kenyatta Barron's family addressed the court, speaking directly to O'Neill about the lifetime of pain he had caused and the screams they hoped would haunt him for the rest of his days. Finally, Judge Michelle Sisko spoke. She described the crime as uniquely horrifying and admitted that viewing the evidence, particularly the photographs, would haunt her forever. She explained that it took everything she had not to break down during the trial. Then she imposed a sentence. Ronnie O'Neill was given 3 consecutive life sentences, each without the possibility of parole. In the end, O'Neill didn't outsmart the system. He didn't expose corruption. He didn't control the narrative. By representing himself, he became his own worst witness, questioning the one person who could destroy his defense and confessing in open court. Well, it doesn't end here. The next defendant decided the courtroom is the perfect place to lecture the judge, challenge the legitimacy of the entire legal system, and turn a routine arraignment into a one-man protest. Number 5. How Leonard Blatt tried to bully the bench and lost control of the hearing. In Washington state, that answer came in the form of Leonard Blatt, a man who transformed what should have been a 3-minute procedural hearing into a 38-minute courtroom standoff. Leonard Blatt wasn't in court for anything exotic or complicated. According to the charging documents, he was facing several low-level but serious traffic-related offenses: driving with a suspended license in the 3rd degree, operating a motor vehicle without insurance, failing to transfer a vehicle title within the required 45 days, and a trip permit violation. These are the kinds of cases judges handle dozens of times a day, often resolved in minutes. But Blatt had no intention of resolving anything quickly. From the moment he addressed the court, it was clear he wasn't there to discuss his charges. Instead, he launched into a sweeping critique of Washington's judicial system, declaring that while he respected the law, he believed judges across the state routinely ignored it. He claimed corruption was endemic, not just in the courts, but in law enforcement as well. The judge at the bench that day, Judge July Simpson, was serving as a pro tem judge, a temporary appointment filling in for an elected judge. Her role was simple: ensure Blatt understood the charges, advise him of his rights, and take a plea. But Blatt quickly made it clear he had no interest in participating on those terms. Judge Simpson patiently explained the purpose of the arraignment and provided Blatt with printed copies of the charges. She noted that he had declined to speak with a public defender and offered him time to review the documents. That should have been the end of it. Instead, Blatt doubled down. He compared being a judge to engaging in a hazardous activity, arguing that judges, like drivers, should be insured against the damage they cause. The irony went unacknowledged. Blatt himself was accused of driving without insurance. He pivoted seamlessly into another speech, insisting he had no respect for Washington courts due to what he described as corruption, arbitrary behavior, and professional misconduct. At one point, Blatt claimed prior experience working with the Seattle Police Department, alleging widespread white-collar fraud involving police unions and advertising schemes. None of it had anything to do with his suspended license or insurance violations. Still, Judge Simpson allowed him to speak, offering minimal interruption. Then came the turning point. Blatt asked who she was. Judge Simpson calmly introduced herself, explaining that she was a pro tem judge serving temporarily. That single detail changed Blatt's entire approach. Sensing an opening, he immediately began questioning her authority. He announced that he had attempted to locate her oath of office and bonding information online but couldn't find it. He demanded to know whether she had officially taken an oath and where it was filed. He added that he intentionally did not stand when she entered the courtroom, citing Supreme Court rulings about symbolic speech and claiming that standing would signal respect, he said Washington courts had not earned. At this point, many judges would have issued a warning or initiated contempt proceedings. Judge Simpson didn't. She listened. Blatt took that as permission to escalate. He veered into a long, unrelated rant about domestic violence cases, claiming that men accused by women in Washington are presumed guilty, denied bail, and pressured into perjuring themselves to secure release. He framed the justice system as fundamentally biased and hostile, citing personal experiences that, once again, had no relevance to the charges before the court. When Judge Simpson attempted to steer the hearing back on track, Blatt refused to recognize her authority altogether. He told her she had two choices: proceed under his terms or step off the bench. He argued that only an elected judge, not a temporary appointee, could be held accountable. Then something unusual happened. Judge Simpson agreed. She acknowledged that defendants have the right to request an elected judge and stated she would step aside so the case could proceed without further delay. It was a move that diffused the confrontation without escalating it, and one that Blatt likely did not expect. An elected judge with significantly more courtroom experience soon took the bench. His tone was calm, firm, and unmistakably authoritative. He called Leonard Blatt forward and clearly listed the charges, one by one. He explained Blatt's constitutional rights, including the right to an attorney and the option of having one appointed if he could not afford private counsel. It was a textbook arraignment restart. Blatt immediately attempted to resume his monologue. He began talking again about domestic violence cases and alleged misconduct by attorneys. This time, the judge cut him off. Firmly, he explained that domestic violence had nothing to do with the current case, and that past grievances were not relevant to the proceedings at hand. Blatt then refused to enter a plea. Under Washington law, if a defendant refuses to plead, the court is permitted to enter a not guilty plea on their behalf to allow the case to move forward. That's exactly what the judge did. Blatt objected loudly, insisting that no plea had been entered and accusing the court of rushing him through due process. He demanded the plea be withdrawn. The judge acknowledged the objection but made it clear the plea would stand. Next, Blatt argued that he could never receive a fair trial. His reasoning was elaborate. He claimed that jurors would be biased because they possessed driver's licenses issued by the same government prosecuting him. He pointed to the American flag behind the judge as evidence of institutional bias. He argued that public defenders were beholden to the state because they were licensed by it. In his view, everyone in the courtroom represented the plaintiff, the government. The judge didn't debate him. Instead, he explained the proper legal avenue for such concerns. File a written motion, present evidence, and argue it before the court. Philosophical objections, no matter how passionately delivered, were not substitutes for procedure. With that, the judge set future court dates, confirmed that Blatt would receive reminders, and concluded the hearing. What should have been a brief arraignment had stretched into a 38-minute ordeal, not because of legal complexity, but because Blatt refused to engage with the process. His attempt to bully the bench, derail proceedings, and overwhelm the court with rhetoric ultimately failed. Blatt's courtroom theatrics didn't change the outcome. On appeal, the Washington Court of Appeals shut down his claims, ruling that he had knowingly and voluntarily waived his right to an attorney after repeatedly rejecting representation. The judges found no constitutional violation, no procedural prejudice, and no legal basis to overturn the case. His jurisdictional arguments went nowhere, and his habeas petition was denied. In the end, the higher court affirmed the lower court's decision, leaving Blatt's conviction and penalties firmly in place. Proof that defiance and speeches don't override settled law. Away from Blatt's back and forth, what happens when a defendant refuses to identify himself in open court and insists he's merely representing the accused, who also happens to be him? Number 4. How Matthew Neil Aldridge tried sovereign tactics in court and failed. In a Tennessee courtroom, that exact scenario played out, turning a routine plea hearing into a masterclass on why legal wordplay doesn't outrank the law. The case centered on Matthew Neil Aldridge, who appeared in a Tennessee circuit court for a scheduled plea date ahead of a looming trial. From the very first question, things went off the rails. The judge, Judge Wolf, asked a simple, procedural question. Was the man standing before the bench Matthew Neil Aldridge? The court needed confirmation to proceed. Aldridge refused. Again and again, the judge asked him to identify himself. Again and again, Aldridge dodged. When he finally spoke, it wasn't to answer the question, but to announce that he was acting as the attorney of fact for Matthew Aldridge. The courtroom paused. Judge Wolf immediately pressed for clarification. Was he a licensed attorney? No. Did he have a power of attorney authorizing him to represent Aldridge? Also no. That left only one logical conclusion. He was Matthew Aldridge. He just wouldn't admit it. The term attorney of fact, Judge Wolf explained, has no standing in criminal court. Only a licensed attorney or the defendant himself can speak on a criminal defendant's behalf. Anything else isn't clever. It's unlawful. The judge warned Aldridge plainly that attempting to represent someone as an attorney without a license could expose him to serious legal trouble under Tennessee law. Still, Aldridge held the line. When asked his name directly, he hesitated, then claimed he didn't have a name. The judge, visibly unimpressed, reminded him that criminal proceedings don't pause for philosophical arguments. Courts deal with people, not riddles. Aldridge then claimed he had paperwork to support his position. Judge Wolf allowed him to present it. The document was handed to the bailiff and passed to the bench, and that's when things unraveled even further. The paperwork wasn't filed in the correct court. It referenced a chancery court in the wrong county, even though Aldridge was standing in circuit court. Worse, the document was packed with irrelevant civil case citations, Latin phrases taken out of context, and references to cases that had nothing to do with criminal law. One citation referenced Rundle versus Delaware and Raritan Canal Company, a 19th century civil case, hardly applicable to a modern Tennessee criminal proceeding. The letter culminated in a demand that the state of Tennessee prove its standing within 15 days or cease and desist all action against Aldridge. Judge Wolf didn't mince words. Filing pseudo-legal documents filled with jargon doesn't strip a court of jurisdiction. Criminal law doesn't evaporate because someone declares it invalid on paper. But there was one detail in the letter that did matter. At the bottom was a signature, Matthew O'Neill Aldridge. Judge Wolf pointed to it and asked the obvious question. Was that his signature? Aldridge refused to answer. That was enough. Since the individual before the court would not identify himself and had no legal authority to represent anyone else, Judge Wolf made a formal finding. Matthew Neal Aldridge had failed to personally appear for his plea date. As a result, the court treated the situation as a non-appearance, despite the fact that Aldridge was physically present. The judge then addressed the elephant in the room. He stated clearly that he recognized the tactics Aldridge was using, methods commonly associated with sovereign citizen ideology. These strategies often involve denying jurisdiction, refusing to acknowledge identity, and flooding courts with meaningless paperwork in hopes of delaying proceedings or forcing dismissal. Judge Wolf shut that down immediately. The court's authority, he explained, doesn't come from magic words or paperwork traps. It comes from the United States Constitution, the Tennessee Constitution, and the citizens who elect judges to enforce the law. No amount of legal-sounding language changes that. Aldridge attempted to ask questions about his case, but the judge stopped him. Without confirming who he was, Aldridge had no standing to speak. Judge Wolf reminded him that wasting court time also wastes the time of every other citizen waiting for their case to be heard. Finally, the judge issued a blunt warning. If Aldridge was Matthew Neal Aldridge, and everyone in the room knew he was, this was his last chance to resolve the matter before trial. The court would not play along with identity games. Rather than wait for confirmation that wasn't coming, Judge Wolf set a trial date. He addressed the order to Matthew Aldridge and the individual standing before me whose name must not be uttered, making clear that the case would proceed whether Aldridge liked it or not. And with that, the moment ended. Matthew Neal Aldridge left the courtroom, having successfully avoided saying his own name, but completely failing to avoid the law. The next case is even more ridiculous. The defendant treated the courtroom like a comedy club and even tried to flirt with the judge. Number 3. How Penelope Soto turned a bond hearing into a jail sentence. For Penelope Soto, a routine bond hearing in Miami turned into one of the most infamous courtroom meltdowns ever caught on camera, and it all unraveled in a matter of minutes. Penelope Soto's case began in 2013 when she approached police officers and admitted she was carrying Xanax bars. The honesty didn't help much. She was arrested and charged with possession of a controlled substance, then brought before Miami-Dade Circuit Judge Jorge Rodriguez Chomat for her arraignment and bond hearing. On paper, it was a low-level drug case. In reality, it was about to become viral history. At first, everything seemed normal. Soto answered basic questions and even managed to make the judge laugh briefly, prompting a light exchange. But the tone changed when Judge Rodriguez Chomat began asking about her financial situation, information needed to determine whether she qualified for a public defender and what bond amount was appropriate. Soto said she worked and earned around $200 a week. Then came the assets question. Did she own property? A car? Bank accounts? Jewelry? That's where things went sideways. Soto casually claimed she owned a lot of jewelry, delivering the answer with a grin that made it clear she wasn't taking the hearing seriously. The judge pressed her for specifics. How much was it worth? Soto laughed again. The judge stopped her immediately, reminding her that court was not a club and that bond hearings were not a joke. Trying to recover, Soto insisted she was being serious, right before undercutting herself entirely. When asked again to estimate the value of her jewelry, she replied that it was worth like Rick Ross. The reference to the rapper left the judge visibly unimpressed and thoroughly confused. The humor was gone now. Judge Rodriguez Chamat explained that if Soto truly owned substantial jewelry, she could afford a private attorney and didn't qualify for a public defender. He set her bond at $5,000, signaling that the matter could end there if she simply walked away quietly. Instead, Soto waved and cheerfully said, "Adios." That was the moment everything collapsed. The judge immediately called her back, irritated by what he interpreted as blatant disrespect. He doubled the bond to $10,000 and made it clear he was no longer amused. Soto reacted with disbelief, asking if he was serious. He was. Still, it wasn't over. As deputies escorted Soto away, she flipped the judge off and muttered an insult under her breath, a gesture and comment clearly audible in the courtroom. That single action transformed a bond hearing into a criminal contempt proceeding. Judge Rodriguez Chamat ordered her brought back again. This time, the tone was ice cold. The judge asked Soto directly if she had made the obscene gesture and insulted the court. She admitted that she had. With that confirmation, the judge found her in direct criminal contempt and sentenced her to 30 days in county jail on the spot. Soto's reaction was defiant. She loudly declared that the sentence was fine, showing no immediate remorse as deputies led her away. But reality has a way of sinking in once the cell door closes. When Soto returned to court later, her demeanor had completely changed. Through her attorney, she issued a public apology, acknowledging that her behavior during the bond hearing had been immature, disrespectful, and irrational. She apologized not only to the judge, but also to her family, admitting she had embarrassed them. Judge Rodriguez Chamat took the opportunity to explain just how serious the situation had been. He reminded Soto that contempt of court can carry lasting consequences, and warned that continued behavior like that could derail her future entirely. He emphasized that she was young, intelligent, and had a life ahead of her, but only if she learned when to take things seriously. Soto assured the court that she understood and accepted responsibility. After hearing the apology and considering her age and lack of prior serious offenses, the judge reversed the contempt ruling. He vacated the remaining jail sentence and allowed Soto to move forward without the 30-day penalty hanging over her head. The moment went viral for its shock value, but it also became a cautionary tale. Well, this next defendant, who's a convicted killer, mocked a victim's family right in front of the judge and assumes the deal protecting him can't be touched. Number 2. When Danta Wright nearly lost everything in court. In one chilling courtroom moment, overconfidence nearly cost Danta Wright the rest of his life. Danta Wright was identified by prosecutors as the trigger man in the killing of 18-year-old Jordan Klee, a crime that stemmed from a planned robbery that spiraled out of control. According to court records and sworn testimony, Wright and 2 associates conspired to rob Klee, believing the encounter would be quick and easy. Instead, it ended with a young man dead and 3 teenagers facing murder charges. During Wright's plea hearing, prosecutors laid out the facts with methodical precision. On October 4, 2016, Wright admitted that he had agreed with Delmino Gracie and Jarius Ellison to commit an armed robbery. Under questioning, he acknowledged his role in the crime. First the plan, then the confrontation, and finally the gun. When asked directly what happened to Jordan Klee, Wright calmly explained that he shot him in the head. There was no visible emotion, no hesitation, just answers. That lack of emotion would become the defining feature of his sentencing. By the time Wright appeared before the judge to receive his sentence, he had already entered into a plea agreement that spared him from a possible life without parole outcome. The deal, negotiated by both sides, recommended a lengthy but finite prison sentence. On paper, it looked like the worst was behind him. Then the victim impact statements began. Members of Jordan Klee's family addressed the court, describing a future that had been stolen forever. They spoke about college plans that would never happen, birthdays that would never be celebrated, and choices Jordan would never get to make. One relative read a statement on behalf of Jordan's mother, explaining how grief had turned into something darker, a hatred she had never felt before. Her words were raw, painful, and devastating, and while those words echoed through the courtroom, Danta Wright smiled. He rubbed his hands together. He shook his head. At times, he looked almost amused. The reaction stunned everyone in the room, including the judge. When Wright was finally given a chance to speak, the courtroom waited for remorse, or at least acknowledgement of the pain he had caused. Instead, he brushed it off with a few dismissive words, insisting he would be home soon, and declaring his love for his family. The judge's response was immediate and sharp. "That's all you've got to say?" she asked. What Wright didn't seem to realize, at least not at first, was that his plea deal was not guaranteed until the judge formally accepted it, and judges have discretion. The judge explained that in more than 2 decades on the bench, she had almost never rejected a negotiated sentence agreement. But watching Wright smile, laugh, and behave as if the proceedings were meaningless pushed her to the edge. She openly warned that she was considering throwing out the deal entirely. If that happened, Wright would face trial for felony murder, a conviction that could result in spending the rest of his life in prison with no chance of release. "That means you'll die there," the judge said plainly. For the first time that day, Wright's expression changed. He turned to his attorney and asked, visibly shaken, whether the judge could really do that. The answer was yes. Sensing the gravity of the moment, Wright's lawyer stepped in, attempting damage control. He reminded the court that Wright was only 17 years old at the time of the crime, and argued that his behavior wasn't arrogance, but fear. Some people, he said, smile or laugh when they're terrified and emotionally overwhelmed. The courtroom then returned to the victim's family. Despite Wright's behavior, they made a request that surprised many observers. Seeking closure rather than prolonging the case, the family asked the judge to honor the plea agreement. They acknowledged the brutality of the crime, the lack of remorse, and even evidence that Wright had written violent rap lyrics while in custody. But they wanted the case to end. That request carried weight. After considering the family's wishes and the agreement reached by both sides, the judge accepted the plea deal. Danta Wright was sentenced to 23 to 50 years in prison. Even as the sentence was handed down, Wright showed little visible emotion. In the end, his behavior didn't undo the deal, but it came dangerously close. When it comes to smiling in the court, this next defendant took it to a whole new level. Number 1. The clown case of Kenneth Crowkunas. In Milwaukee, Kenneth Crowkunas, a political activist and self-described performance protester who quite literally showed up to court dressed as a clown. Crowkunas first made headlines after an incident outside Milwaukee City Hall, a place he had frequented while staging protest-style demonstrations. Known locally for donning clown makeup and costumes to criticize government authority, Crowkunas attracted police attention when he was accused of creating a public disturbance. According to court records and police reports, officers responded to complaints that he was chasing passing vehicles and spraying a squirt gun at cars, behavior authorities said posed a safety risk in a busy downtown area. When a Milwaukee police officer attempted to question him, the situation escalated quickly. Crowkunas resisted, and the encounter ended with both the officer and the costumed protester wrestling on the ground in full public view. The footage spread rapidly online, mostly because it looked less like a law enforcement encounter and more like a slapstick routine gone wrong. Despite the absurd visuals, the charges were real, and Crowkunas was formally cited in connection with the incident. Then came the courtroom appearance that turned an already strange case into a viral spectacle. Crowkunas arrived dressed exactly as he had been outside City Hall. Red nose, clown attire, the whole package. The bailiff ordered him to remove the nose before proceedings could continue. Crowkunas complied, but not without commentary. When instructed to take a seat, he openly questioned whether it was a lawful order, jokingly claiming he charged $1,000 for following it, and even asked for the bailiff's name so he could send a bill. The courtroom remained tense, but the judge allowed the hearing to proceed. He was released on a $2,000 bond and ordered to return the following month. And in what was either a protest statement or a complete refusal to read the room, Crowkunas came back, once again, dressed as a clown. Presiding Judge Bonnie Gordon made it clear she had reached the end of her patience. She instructed Crowkunas to appear in proper courtroom attire and warned him not to interrupt the court. Crowkunas repeatedly demanded a written order, insisting he needed documentation to take to his attorney. Each interruption only worsened his position. Judge Gordon explicitly warned him that his behavior and language were disrespectful and that continued disruptions could result in contempt of court. While Crowkunas narrowly avoided a contempt charge that day, the judge chose to reschedule the hearing instead, a decision that arguably spared him from immediate consequences, but cemented his place in viral court history. Thanks for watching. See you in the next one.